Ms. Ellsworth?
Mr. Chief Justice, and may it please the Court, in 2016 and 2021, FDA made certain changes to the labeling and use restrictions for Danco's drug Mifepristone. The decision below stops Danco from selling Mifepristone in line with that scientific judgment based on a highly attenuated claim that an unknown doctor could be called someday to an unknown emergency room after a series of decisions by third parties. No facts causally link that possible future encounter to a specific change FDA made in 2016 or 2021. Respondents' view of the Food, Drug, and Cosmetic Act is so inflexible it would upend not just Mifepristone, but virtually every drug approval and REMS modification FDA has made for decades. Reversal is required for two reasons. First, Article III standing is not an academic exercise in what's conceivable. Respondents lack standing under every prong of the analysis. Second, on the merits, FDA exhaustively considered the evidence and reasonably explained its conclusions, which is what is required to do. I welcome the Court's questions.
The government, the Solicitor General points out, would not be susceptible to a Comstock Act problem. But in your case, you would be. So how do you respond to an argument that mailing your product and advertising it would violate the Comstock Act?
Justice Thomas, we agree very much with the government that FDA's charge under the Food, Drug, and Cosmetic Act is limited to looking at safety and efficacy considerations. That's true for new drug approvals. It's also true for REMS modifications. FDA routinely approves drugs whose manufacture and distribution is restricted by other laws, like the Controlled Substances Act, environmental laws, customs laws, and so on. I think this Court should think hard about the mischief it would invite if it allowed agencies to start taking action based on statutory responsibilities that Congress has assigned to other agencies. On the merits, this issue was not presented below, was not ruled on below. And in any event, I would also point out that in 2021, FDA's decision allows use of brick and mortar pharmacies in addition to mail order pharmacies.
Well, my problem is that you're private. The government, I understand the government's argument, but you're private, and the statute doesn't have this sort of safe harbor that you're suggesting, and it's fairly broad, and it specifically covers drugs such as yours.
Your Honor, we disagree that that's the correct interpretation of the statute, but we think that in order to address the correct interpretation, there would need to be a situation in which that issue was actually teed up. This statute has not been enforced for nearly 100 years, and I don't believe that this case presents an opportunity for this Court to opine on the reach of the statute.